Starting just generally with the Constitution, we understand that the Constitution provides a Bill of Rights. Those are the first 10 amendments to the Constitution. And those Bill of Rights were originally dealing with the federal government, but they were eventually incorporated through the 14th Amendment. Incorporation means that it's been held against the states as a kind of floor or baseline of rights that people are expected to have no matter what state they are in. Dealing with police encounters, we're going to be focusing in on the Fourth Amendment and the Fifth Amendment. And the Fourth Amendment provides the right of the people to be secure in the persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And we're focusing here on unreasonable searches and seizures. Because when we talk about police encounters, we're talking about whether an officer has caused a seizure to occur by restraining your ability to move, in other words, telling you to stop or possibly arresting you, maybe even touching you or touching your private property, and of course related searches. Is an officer going into your pockets? Is an officer looking through your belongings? What constitutes a search? Those types of issues really come up when we look at police encounters. And we're going to be focusing a little bit more on the seizure aspect when we're talking about police coming to talk to you in the public sphere. Talking about the Fifth Amendment now, also of importance here is that you shall not be compelled in any criminal case to be a witness against yourself, nor deprived of life, liberty, or property without due process of law. What this has gone to mean, generally speaking, is that an individual does not have to incriminate themselves. In other words, generally speaking, a person doesn't have to speak to police. A person doesn't have to offer up information. There are some certain exceptions, and we'll cover a couple of those in some upcoming slides. But generally speaking, on the street, you're not required to talk to a police officer simply because they want to talk to you. So you don't have to worry about that issue. Now, we're going to talk about probable cause. You've probably heard that, or PC for short, on lots of TV shows where there's, arrests being made and there's like courtroom dramas and, CSI, things like that. You hear probable cause thrown around a lot, and generally speaking, probable cause exists where the facts and circumstances within the arresting officer's knowledge and of which they had reasonably trustworthy information are sufficient in themselves to warrant a man of reasonable caution in the belief that an offense has been or is being committed. And that's very verbose and wordy and confusing, but the short of it is that probable cause is a standard that an officer has to reach in their knowledge when meeting somebody on the street in order to make an arrest on the street. In other words, an officer has to see these facts and circumstances at a reasonably trustworthy level related to criminal activity in order to make an arrest. So the short of it is an officer on the street is not going to just be able to walk up to a random person and throw them in jail. That is a part of due process that is protected and incorporated through the 14th Amendment, which states are required to provide. Reasonable suspicion is going to be another point of topic upcoming, and so I'm just making these definitions clear. A reasonable suspicion is a lower standard than probable cause, and that's often where we hear that whole Terry stop idea. If you ever have seen someone just stop in the street and then you see the Terry stop pat down, that typical officer patting somebody's outer clothing down, that's what we think of when we think of a reasonable suspicion stop. And a reasonable suspicion stop happens when officers have specific and articulable facts which indicate that a crime is being, or is about to be committed. It's not as high as probable cause, but it's enough that officers see facts which make them think that a crime is about. And this has to be more than a hunch or a general suspicion. In other words, officers can't just say, oh, that person walking down the sidewalk looks suspicious. It can't just be, oh, that person is a minority and they have a backpack. I have a hunch that they have drugs. There's still a level of protection that has to be metered out when it comes to carrying out reasonable suspicion stops. And reasonable suspicion stops basically mean that an officer is able to detain a person, that is, tell you that you can't move from somewhere, for a brief period of time. And that time period has depended on whether or not an individual is committing a certain type of crime which requires a lot of investigation. On the short end, for traffic stops, as some people might be accustomed to, those are supposed to only last, about 15 minutes at most. Someone that maybe doesn't have a bicycle helmet or bicycle light and a city ordinance requires it, the officer's only supposed to write them a citation that should take 10 to 15 minutes tops, and that's it. That's all they're allowed to detain for with those types of short stops. And that being said, there are instances where an individual can be held for longer. And that is an example of that was a woman who was trafficking drugs and balloons inside of her intestines, you might say. Officers were able to hold her for about 24 hours. But again, that's an unusual case, and typically speaking, people can't just be held wantonly. There has to be a real logical connection as to how long somebody is being detained under reasonable suspicion. And of course, that carries also into writing citations, as I just mentioned. Now, talking about compliance on the street. The focus point, again, for this discussion, now that we've gotten this background information out of the way about your Fourth and Fifth Amendment rights, about probable cause and reasonable suspicions, types of stops, is that being approached on a public sidewalk or public place is the area that we're going to be focusing on. Generally speaking, police have a right to make you perform or provide anything until that probable cause standard has been reached, as you've seen. The exceptions that we're going to briefly talk about are where states have reasonable suspicion detention statutes, which allow them to, that is, officers, to demand your name, your birth date, and permanent address. What that really means, it came after a case that stemmed out of Utah, but the Supreme Court approved states allowing an officer who has, again, reached reasonable suspicion for a crime, not just walking up to you randomly on the street and saying, show me your ID or your credentials or something like that. They have to already be stopping you for a crime that they have reasonable suspicion about. If they have that, then they can ask those things. Florida is not one of those states. Florida is not a stop and identify state. In addition, just to note, you'll have to check with your local state, but generally speaking, the identification aspect doesn't mean you provide a state ID. You don't have to provide a driver's license, obviously, if you're walking, because you're not driving. So typically, identification just means stating your name, stating your birth date, and stating your permanent address. Of course, these things could potentially be challenged under the Fifth Amendment, potentially, saying that, it's incriminating to state your name. But as the case law stands, generally speaking, the Supreme Court has upheld that is okay for them to ask, and then if you don't, you might get a resisting/obstruction charge in states that have stop and identify. So, with that in mind, a person needs to establish what the officer is thinking or is doing before making a move to be safe. Because it's really important that whenever you're approached by an officer, you understand what the officer is looking for. Are they looking just to talk? Are they actually just trying to stop you and have a reasonable suspicion detention? Or are they about to arrest you? That's a very big deal. So what is your job? Your job is to be a detective. When an officer approaches you, your job is to figure out the circumstances about which they're approaching you. And of course, in your detective work, determine if it is safe to leave, because the safest thing to do is to get away from police. Consensual encounters versus detention/arrests. Police can obviously talk to you on the street. Police officers, just like any other person, in that they can say hi, hello, how are you doing? They could ask you what's in your purse. They could ask you what you had for lunch. But an officer cannot, at least without the reasonable suspicion or probable cause requisite, they cannot make it seem like you are required to talk to them. They're not supposed to make you believe that you are under arrest or being detained with a show of authority if you're legally not being arrested or detained. Now, that being said, police can lie to you, but when it comes to legally operative words like an officer saying to you, stop, or halt, or you're under arrest, an officer can't really lie about that, because if they do say those things, it leads to issues such as false arrest, potentially. It leads to false detentions. It could lead to evidence being suppressed because the evidence was gained unlawfully. So an officer, at least legally operatively speaking, can't be pretending like, I'm stopping you, or I'm going to arrest you, and then saying, just kidding. Once those levels are met, once an officer says stop or halt, and a reasonable person believes they're being stopped or possibly being arrested, they can't unring that bell. So we have to find out what that police officer is talking to you for, so that you can know what to ask next. So when the initial encounter, if you're approached by an officer, your first job as a detective is to determine your status. And the easiest way to do that is to ask, am I being detained, or am I free to go? And remember to remain calm and still. You don't want to make an officer nervous or anything like that. You want to make them realize that you are confident in yourself, that you know your rights, but without, being really pushy or aggressive. You want to be firm, but you want to, seem very level-headed. And by asking, am I being detained or am I free to go, you are immediately establishing that you are not interested in talking to that officer because you're trying to figure out whether you can actually leave. And so you're trying to make it clear that you are getting out of that situation. And if an officer continues to be evasive or not give you a straightforward answer, that could lead to a potential detention happening. And that is by the law. And so if that happens, that could be a lot of big trouble because anything the officer says or does afterwards could be suppressed because it would be an unlawful detention if they didn't have reasonable suspicion. And not only that, there could be civil damages if a lawsuit was successfully launched. So if the officer then says that no, you're not being detained, immediately this should be your cue to get out of there. Now, it doesn't mean that you should start, running full speed the other way, potentially arousing some sort of suspicion or nervousness. Now, that being said, there's another issue which we won't be talking about today, and that's, when fleeing from an officer can turn into reasonable suspicion. We're not going to talk about that, but generally speaking, this is just a safety measure. It's a good practice. You just say thank you and good day and walk away calmly. Why? Because you're just letting them know you're not interested in talking, and you're getting out of there in a safe and decent manner. Nobody can say that you were disrupting the peace. Nobody can say that you were threatening anybody if you walk away calmly and confidently. And that's really key. You don't want to cause any more conflict that you need, and you want to create the best possible case for yourself in the event that your rights are violated. Just plain and simple. However, now, if that officer then does say, yes, that you're being detained, you're in a different world, and your detective hat has to be tipped up a little bit more because you have a lot to research. First, what you need to find out is why you're being detained. Ask the officer straightforward. Why are you being detained? It's important to know what exactly you're being detained for. Why? Because that could be used against the officer later in court if the officer ends up, saying something different. If the officer tries to pretend that they detain you for one thing but really was another, that could be a huge impeachment aspect. Especially where officers are making things up or trying to play that they can do anything. And I've personally have been in those situations where officers have tried to do that to me. Very irritating. Even while in law school. So it's really important to make sure that you get them on the defensive, not in an aggressive way, but in a logical way. You're letting them know that you're building a case for yourself, and you're going to get to the bottom of this. If the officer then says anything other than, and we're talking about from Florida now, for loitering or prowling, and loitering or prowling is just an interesting issue in Florida. It's not, it's one of those things where you have to show your ID or anything like that. The issue with loitering and prowling in Florida is that one of the circumstances around which there's suspicion is refusal to state your name and address with loitering or prowling. However, stating your name and address is not an element of the crime. It's a really very intricate legal issue. But the short of it is we're just going to focus really more on, what you need to do generally, okay? So when the officer responds to you, maybe they said, "Oh, we heard that someone was, maybe if you're a young person, underage drinking. We heard something about, somebody tampering with a car." You don't respond to any of those things. You're just there to receive that information so you know for the future what it is that they were looking for. Next, you need to get their badge number and name. Why? Because generally speaking, in police procedure manuals, they are supposed to give you their badge number as a way for the public to know that they're a real police officer and not an imposter. So it may be difficult to actually take that information down. Obviously, do the best that you can, but try to remember their name. Try to remember their badge officer. Their badge number, the badge number of the officer. And that way you have that for the future in the event that, you need to file a complaint or file a lawsuit. Ask to speak to the supervisor. It's not always true that they have to get their supervisor on the scene, but it does let the officer know that you're serious, that you are very disturbed that you're being detained. And of course, at the end of that, ask if you're still being detained. Plain and simple. Your job is to get out there as soon as you can. You need to ask as often as you can whether or not you're being detained and if you're free to go. Obviously, don't do it to the point of being aggressive or obnoxious, but do this every 30 seconds to a minute. You need to find out as soon as you know or can know when you can get away from that situation, because officers are not really required to tell you when it's passed, when that reasonable suspicion is passed. They'll say stop, to let you know that you've been stopped, but they don't have to say, oh well, sorry, it's over. You need to ask, and if you ask and they continue past that, then they're setting themselves up for trouble. So, going to this next slide, now we're going to bring it back to that loitering and prowling issue with Florida. Again, asking for your badge and number and name is important. You want to speak with their supervisor because you want to figure out why. You could ask why the officer thinks you're loitering or prowling. Again, you're building a case for yourself. Ask what he wants to know to determine if you're not loitering or prowling. Again, the best thing you could do for yourself is to not do or say anything that could be incriminating. It's to ask the officer what's on his mind, and he or she may not respond, but you are getting it out there. You're putting the opportunity for them to create a record against themselves. That's the point that you're trying to do, and the officers are trying to do the same against you. So you're just trying to stay ahead of them. And again, do not say anything except to ask if you're still being detained, and do this once, every minute or 30 seconds or so until the officer no longer detains you, because again, they may not let you know that you are free to go. And this, again, this is more of a Florida-specific issue, but if an officer demands identification, this is a real judgment call. But generally speaking, you could give your actual legal name, date of birth, potentially, your home address that they ask, but really be careful, because I have seen instances where people get tripped up. They sometimes they give an address that maybe was their student address. It's not really their permanent address, and they look it up in their license. They try to say, why are you lying? I mean, I've seen really crazy stuff, which is why, it's a really gut-wrenching issue. But with loitering or prowling, it's kind of scary. You try to do your best you can to give the information that you think is safest. If you think your date of birth and your name is easy to say, they can't get that wrong. They're not going to be like, oh, you actually have 2 addresses, and so we're going to arrest you. That's the best way to do it, is to be as safe as possible. And you don't need to give an officer any forms of ID. Again, walking on the sidewalk, we're talking about public places. Maybe you're walking in a public park that's completely open. You're walking at a boardwalk, you're walking at a sidewalk. You don't have to give an officer an ID, in as much as, you don't have to show a pilot's license to drive a car. Again, the ID part, if any, which is only relevant in Florida to loitering and prowling, is dealing with saying your name, date of birth. So coming back to the general. If an officer now does not give a direct answer to you, in other words, you've asked these questions, he's being evasive, again, do not speak except to ask, again, what their badge number and name is, that you want to speak to their supervisor, ask whether you're being detained, ask if you're free to go. It's the same thing. Doesn't matter what it is, an officer that's being evasive, you need to get that information. It is so critical that you get out of there. And the biggest one, if for safety reasons, is if you're free to go. Of course, it'd be great if you can get the badge number right there and then. You may have to, read it and take note, because they're not saying it to you. You might have to try to look at their, little badge in their chest. But your goal is to be safe, and so you want to be able to get out of there as soon as you can. Now that we have that general background, and I know it's been complicated and long so far, but that's why I guess there's lawyers, because there's just a lot of complicated issues to go through. So now we're at that point. You're detained. Maybe the officer has told you their badge number. Maybe he said you're being detained for, someone was suspiciously looking, through someone's car or something like that before. Okay, you're detained. Great. Now what? The officer is standing there, and they might be telling you to do something, right? You're wondering, do I have to comply with anything now? Well, an officer, when it comes to just the reasonable suspicion, as we talked before, does not have a right to make you positively do anything, generally speaking. An officer might ask you to sit down on a bench or sit down on a curb, or maybe, imagine you're walking across a street and they stop you, say, hey, stop. You might come back to the sidewalk so you're not standing in the middle of the road. Those might be simple ways that an officer could potentially, lawfully and legally command you to move, which might be sitting or standing, or, moving within just a couple of feet. Because the problem is that if an officer asks you to move any farther really away than a very small radius, like in other words, makes you step a couple more steps in where you've been stopped, that could lead to a de facto arrest. If the officer says, oh, we're going to make you hop in the car, even though it's just detention, just reasonable suspicion detention, that could lead to a de facto arrest by the law. So again, your legal obligations here, when you're detained, are pretty much just to remain still, and, just be calm and not go anywhere. And of course, with that, you want to just be as reasonable and level-headed as possible and know that you're going to get through this. Don't be jittery, don't be fidgety all over the place. You don't want to add any more suspicion than you need. You want to be able to get out of there. So again, and there's these police tricks that they'll try to do to get you to move. I mean, this is very common. Police officers try to, get you to expose things out of your pocket. They try to get you to pull things out. They try to get you to incriminate yourself. And at a fundamental level, at the end of the day, that argument can always be advanced. You can always advance an argument that of the Fifth Amendment saying that you didn't maybe move 2 feet or sit down because you thought it would incriminate yourself. That being said, it's a judgment call that you're going to have to make. It's not always easy, but you do have that backup that could be used. And that goes, again, for what I was talking about before with giving your name and ID. There is always that backup argument, Fifth Amendment, self-incrimination, you are avoiding that. But these are just general practice tips. So when an officer asks you to do something, maybe they say, do a hula hoop dance. Not really. They're probably not going to ask you that. But usually they'll say, would you mind emptying your pockets? That's a very typical one. You need to ask the officer, are you asking me or are you ordering me? Because when it comes to reasonable suspicion, an officer cannot make you empty your pockets. Even with, and this is a side issue, that Terry pat down that you might see in a TV show where an officer pats the outer clothing. It's not supposed to be, going in your pockets, checking your underwear, and going through your waistband type of thing. An officer is supposed to just, with a Terry, pat you down for weapons, and that's an independent reasonable suspicion. And I don't want to get too sidetracked with it because I could make a whole other video on it. But the short of it is that an officer to be able to touch you past the reasonable suspicion point, they have to have another level of reasonable suspicion for a weapon. So in other words, you can't just be stopped. Maybe an officer thought you didn't have a bike light on the back of your bike and, there's city ordinance. An officer can't then just pat you down for, a machine gun or a machete when that has nothing to do with anything. That officer needs independent reasonable suspicion, like a handle of a gun bulge in your pocket or something like that, in order to pat you down, do that Terry pat down. Again, the key operative words here are that you want to find out what the officer is doing. Is he asking you? Is he ordering you? And be careful, because even an officer might order, sufficient movement of you. It's really one of those things that, can lead to a de facto arrest, depending on where the officer tells you to go or move or this or that. And ultimately, at least for the reasonable suspicion aspect, the rule of thumb is that an officer will do the act that they want to do and will be able to legally perform it without your help. Okay, if you're detained just on reasonable suspicion, the officer, has some facts they think you have committed a crime. It's not probable cause yet. If that officer thinks they have the legal authority to make you empty your pockets or this or that, they'll just do it. If they've reached that probable cause level, they don't need to ask your permission. That's the key. They don't need to ask you to, jump them down, do jumping jacks, or lift your hands, or pull your hands to your pockets. If the officer really thinks that they have the legal authority to do that, they'll go ahead and do it. And you just got to let the chips, fall where they lie. Of course, be limp. Of course, be relaxed. Of course, be calm. Don't resist with force. But generally speaking, you're not required to move or do anything incriminating when you're detained under reasonable suspicion. You want to avoid moving as much as possible. You want to be relaxed. You want to keep your hands out of your pockets if you can from the beginning, to avoid further suspicion. But an officer may ask you to remove your hands from their pockets, but it's a judgment call. Again, an officer thinks they have the legal authority to do something, they'll just do it. It's not per se obstruction to remain just common standing when you've been detained under reasonable suspicion. And again, the Fifth Amendment backup. There is always that statement that you can make that the Fifth Amendment protects you from incriminating yourself. And here's the big one. If arrested, which is not fun for anybody, you have to remember that, being arrested is really, really a horrible experience, but you're going to make it through, and you need to be calm during that portion so that you can make it through. And once you've been arrested, you need to say that you reserve your rights, including your right to remain silent, and you have to ask that you want your attorney present. Okay, it's really important that you have both. Why? Remaining silent may prevent them from, asking you certain types of questions. The officers might be able to ask you questions related to another crime. They might be able to do little things to try to circumvent your silence. They're not supposed to ask you more on that specific question, but again, police officers have been known to try to, get around the law. your best protection in addition to that is the right to remain silent by stating that, which the Supreme Court said that you kind of had to articulate that. So you got to say, I am remaining silent. You also want to say, I want my attorney present, because they have to get your attorney. And you want to repeat that to every officer you pass to ensure that it is well known you want your lawyer. You want to make it absolutely clear that you want your lawyer. I mean, that's a big deal. So any officer you pass as you're walking to the booking station, it may sound silly, you may look goofy, but you want to just say, I'm asking for my lawyer. I want my lawyer. And the reason is that you want no excuses. You want there to be a huge record of people that were there witnessing that you asked for your lawyer. And of course, if there's audio or video being recorded, maybe it's the police station, maybe you're at a gas station, they're happen to have audio or video recording. If you verbalize, I'm remaining silent and I want my attorney, bam, right there, you have that protection. They can't say, oh, we didn't say that, when you have the evidence of you audibly saying, I want my attorney, I'm remaining silent, because they have to bring your attorney before, proceeding with questioning if you actually ask for the attorney. And the officer can't prevent you from verbalizing that request. Okay, maybe you might get a psychopath of a police officer, and they might be like, shut up, or we're gonna, clobber you of the head. But legally, operatively, they can't tell you to shut up and not ask for your attorney. They can't say, shut up. You can't say that you want to remain silent. They can't put a cap on your bottle of your right to be able to ask for an attorney. And here's the big bonus tip for this presentation. Don't resist. And by resist, we're talking about using physical force, okay? This is a little hat tip to the Antonio Buehler video, if you haven't seen that video. In that video, in his Christmas arrest, he had his arms out very, very, very high and wide and was keeping them up very wide. Generally speaking, when it comes to police who are about to arrest you, you want to stay limp and you just want to listen to what the officer says, okay? If the officer says, put your hands behind your back, do so and keep your arms limp, because they're going to move them, and you don't want at any point for them to feel like you're resisting them with force. And in Florida, bring it back to our little bit of a Florida focus, police in Florida are statutorily protected to effect arrests in good faith. And so you can't resist it, even if you might think that they are, acting unlawfully. If the officer is acting in his version of good faith, which you may not know at the moment, you just can't resist. So the safest thing to do, legally speaking, is to just comply. And when they're saying you're under arrest, if they ask your hands behind your back, do that. Just be limp, go gracefully into the car, be calm, and remember, of course, ask for your attorney and say you're remaining silent, okay? This is really important. You want to make sure that you're not getting any obstruction or resisting charges or anything else that they can try to trump up. If there's any video surveillance around, it's been very great that people have video cameras to be able to record people getting arrested, and, different businesses have video cameras of people getting arrested. It shows that if you're caught on video, it shows that you were very calm. It shows that you were relaxed. That really helps out your case. And of course, it's not the end of the world. I personally would imagine that feeling like it was the end of the world, but you have to remember, these are human beings who are responsible to other human beings. And yes, there is, of course, as always, a danger that a police officer is going to act violent. If an officer walks up to you in the middle of the night and starts beating you or trying to kill you, obviously I would anticipate anybody would use reasonable self-defense. But when it comes to just the actual typical arrest, that's it. You have to just realize it's not the end of the world. There's a process and a procedure. You're going to be let go most likely if you make, if you're able to make your bond or be able to get released on recognizance. It won't. This is not a being sent to the guillotines. There is there is life after arrest. So you have to keep calm and you have to realize it's going to be a battle, but you're going to make it. And if you're able to make bond, chances are you'll have a long time where you're just out away from the court, because the actual case may take a long time to actually proceed through. Thank you so much again for your time. If you have a legal issue for which you require an attorney, just search for a bar licensed attorney in your relevant area who can handle your specific need. If you're indigent, you may actually receive a court-appointed attorney if you end up being charged with a crime. You probably heard a little bit about that on TV with those Miranda warnings. If you haven't already heard that, if you can't afford an attorney, one will be appointed for you. What police always say in those TV dramas. And of course, if you are indigent and you need an attorney for other issues, look for a legal aid service in your area. There are many not-for-profits which provide legal aid services, and also many law schools have pro bono clinics. So there are other opportunities that you can check out to get either inexpensive or free legal help if you're in the need. So thank you so much again for your time. Have a great day.